So good afternoon, everybody, and thanks for joining this afternoon session. COVID-19, what an impact it's had, not only in South Africa, but around the world. And our directors and officers are having to respond to some significant changes in their business, and in a very short amount of time, relatively speaking. The impact on this pandemic has been very widespread and is definitely impacting the business operations of all our clients and of our own businesses. And what's important to note is that the liability that could potentially attach to directors and officers for the decisions and the actions that they take during this time is something that we need to highlight and we need to be aware of, and be able to discuss with our clients, but also understand that there is potential for insurance to protect directors and officers at this time. So when we look at the pandemic, within days of COVID-19 being declared a pandemic, the first Dno claims already started to come into the market. And with that in mind, I think it started to highlight the potential for directors and officers to potentially have some big claims against them in their personal capacities and against their businesses for the decisions that they're making at this time. As I mentioned, this was something that directors and officers have had to respond to in a relatively short amount of time. From the date that we first became aware of the disease and the ultimate spread around the world, it was quite a short amount of time and required a lot of decision making and a lot of actions that have ultimately had a big significant impact on business. And I think what's important to understand is that it's also a changing situation. We've already gone through various stages of lockdown, response required in terms of government regulation, and we're yet to understand where this is really going to go. For the next couple months, we are still going to be in a state of having to respond to the fallout around COVID-19. And those decisions are going to require some agility and some flexibility from our business leaders. What I think is important to note and to understand is that the business impact has been significant in that we've moved from office-based business to remote business, and that's impacted on how we interact with our teams, how we manage productivity, how we manage compliance with company regulation and requirements. But more so how we manage the customer and supplier interaction. How do we manage their expectations and their requirements? And how do we comply with the regulations that have been imposed under lockdown? I think it's also important to understand that aside from just compliance with the regulations under lockdown, we also need to take into account the potential legislative responsibility that we have for other pieces of regulation which govern things like employment practices, health and safety, occupational health and safety, data protection, which is a big cause of concern at the moment with everybody working remotely, managing their teams through interaction like this. And then, of course, what we started to notice is a significant amount of industry-specific regulatory bodies providing guidance lines and things that industries have to comply with in terms of their own regulatory bodies. And so these have created a significant amount of regulation and compliance requirements, which create the framework within which directors and officers have to make these decisions and ultimately manage and lead their organizations through a very difficult stage. And I think most importantly, aside from all the government regulation and the regulatory bodies, the most important is that actions of directors must comply with the common law and the codified duties which are identified in the Companies Act. And the Companies Act outlines some fiduciary duties in Section 76. And essentially, these fiduciary duties are the duties that directors and officers must comply with in coming to and making decisions that are ultimately impacting their businesses and stakeholders. So these fiduciary duties state that directors and officers must exercise the powers that they have for a proper purpose. They need to act in good faith. They need to make the necessary disclosures around the decisions that they're making, whether or not there is a personal financial implication to the decision that's being made, for example. They need to act with due skill and care, with diligence when dealing with the company affairs, and in all instances they must be able to show that they've acted in the company's best interests. That's a difficult thing to do at the moment. You know, the question could be asked, well, what is in the company's best interest? Is it to protect and make sure that our people are well looked after and healthy and working remotely? But that, of course, has potential impacts on the revenue and shareholder value in the company. Which do we hold in higher esteem at this point in time? And what is ultimately in the best interest of the company? And we'll touch on that as we go through the presentation. So what are some of the top board risks that we've identified? This is not an exhaustive list, but we've highlighted just some of the areas where we think there's particular risk for directors and officers in making decisions and leading their businesses at this time. And number one, it is the increased regulation and compliance requirements. I think we've noted already that just over the last couple of months, there's been a plethora of government regulation, compliance requirements, which have kind of set the framework in which directors and officers have to make decisions. And so with this risk, it's very important that directors and officers and boards remain informed of those regulations and make sure that you are up to date with the requirements that you are the requirements that you're needing to comply with. And then also remain compliant with all the existing regulation which would govern your organization in the ordinary course. Then there's the risk oversight, and obviously the board responsibility for identification of enterprise-wide risk, but also governance and management of that risk sits with the directors and officers and the boards. And so here it's very important that directors and officers are prepared with a management plan which will enable the continuity of the business through lockdown. That they must have regular meetings with their leadership teams to make sure that whatever plan has been set in place is actually being implemented and managed correctly. And then to document the process in making the decisions and ultimately what has been agreed as a management plan, and make sure that that is well documented. And again, we'll touch on why that's important later on in the presentation. And then thirdly, cybersecurity and cyber risk. I think you would have heard a lot about cyber risk over the last a couple months, but maybe even 18 months, as cyber risk has been identified as one of the top 5 risks for businesses globally. And in this kind of a situation where businesses are being forced online, where companies are having to work remotely with the workforce, it has definitely increased the potential for cyber risk and for breach of personal information. Ultimately, it is the board's responsibility to ensure that there is a well-implemented cyber and IT security plan. It would be very important to make sure that that is documented and that process is rolled out, and that you have obtained an independent assurance as to the effectiveness of that plan and the technology arrangements that have been put in place. And then fourth, but definitely not least, is people. The people are our most important assets in our business, and this has had a significant impact on our people. Boards and directors and officers will be required to make sure that they have implemented the necessary health and safety procedures to make sure that employees are protected at this time, and that while they are working remotely and perhaps out of touch, that management teams make sure that they interact significantly with their employees and make sure that people remain connected and that they are in fact looked after and healthy during this time. So those are a couple of the risks that we've identified. Again, not an exhaustive list, but some of the issues that we just want to highlight as potential concerns for directors and officers. And one thing I just wanted to touch on before we get into the purpose of a directors and officers policy is that within our regulation, we have something called the business judgment rule, which is section 77, subsection 9 of the Act. And essentially what that says is that the appropriateness of a decision will not only be based purely on the outcome of the decision, but on the process that was undertaken to arrive at that decision. And so Where directors and officers can demonstrate that they've taken reasonable steps to become informed of the situation, that they have in fact disclosed any potential personal financial interest in the decision and or other disclosures that are necessary, and that there is in fact a rational basis for arriving at the decision. Within our law, that is a defense for directors and officers. And so that's why it's very important that boards and senior management teams are engaging regularly, that they're interacting with their people, that the processes and the decisions that are ultimately being arrived at this time are well informed and well documented. Because if there is a claim against a director and officer alleging some kind of wrongfulness, it's going to be very important to be able to demonstrate that you have in fact taken reasonable steps to come to that decision, and that it was in fact in the best interest of the company. So the purpose of a Dno policy is essentially there to protect our directors and officers for these kinds of claims, alleging wrongfulness in deriving at a decision that's ultimately had an impact on any of the stakeholders. And the policy is effectively split into 3 sections. The first section being Section A, which is indemnity to the directors in their personal capacity. And this is to protect and defend the personal assets of a director, where there have been allegations of wrongfulness which have ultimately resulted in a loss to an affected third party, and that's not indemnified by the company. Section B is the company reimbursement, and that's to protect the company balance sheet by reimbursing the entity for where they have indemnified a director for a claim that has been brought against them. And then lastly is Section C, which is really to protect the company in the event of a breach of securities regulation. What's really important to understand with directors and officers policy is that the policy advances legal defense costs across all of these triggering clauses, and those defense costs can be incurred, as I say, in advance, but right up until a final adjudication on a matter. So the directors and officers are always protected in their personal capacity for defense of a matter and for ultimately proving that they are able to comply with the requirements of the business judgment rule. So if we just have a brief look at some of the key terms under the policy, and here too we're not going to get into too much detail, but the policy provides an indemnity for claims which are made as a result of a wrongful act. So if we just unpack that, a claim would be any written demand, any civil, regulatory or administrative proceeding. It includes a criminal proceeding, and any wrongful employment practices allegations. So if you go back to where we said there was potential risk, this is the kind of claim that could potentially come against a director or officer. And important to highlight that it includes regulatory and administrative proceedings as well. A wrongful act would be any actual or alleged error, misstatement, misleading statement, an act or an omission, breach of duty. It's important to note here that it doesn't have to actually be a misleading statement or an act or omission, but just the allegation would be enough to trigger the policy. And the loss would include any damages, the settlements, the judgments, or the defense costs that are associated with the investigation. All right, so as we go into the next section, I have a very short video which just really highlights what we've discussed today in terms of the directors and officers liability policy, what the intention of the policy is, and why it's necessary in terms of the requirements under the Companies Act. So I'm going to play this video. It's a very short video, 3 minutes or so. It'll just give us some time to work through any of the questions that perhaps have come up during the session, and then we'll come back online and take any of those questions. Thank you.
Directors and managers of companies make decisions about the management of their businesses on a daily basis. Decisions range from employees, HR, strategy, products and services, suppliers to creditors, strategic direction, risk management, compliance, financial reporting, and so on. It all requires daily big picture thinking. The consequences of these decisions affect various stakeholders, including shareholders, employees, suppliers, customers, regulators, service providers, and potentially society at large. Directors, including managers or officers, are required to apply their minds to every decision they make, to act with due skill, care, and diligence in managing the affairs of the business, and to always act in the best interest of the company. These are known as fiduciary duties. The 2008 Companies Act allows stakeholders to sue directors in their personal capacity if they have been negligent in carrying out their duties and responsibilities. Personal liability means that a director's own assets, such as their property, vehicles, financial assets, etc., which a director may have spent a lifetime accumulating, will be at risk from a single error in judgment or failure to properly understand the impact of a managerial decision. With the ever-increasing demands on management time, it is not inconceivable that even the most experienced director could make an error in judgment, and it would be most unfortunate if that one error cost them their entire estate. A director's and officers' policy will, in line with the law, defend directors or managers for allegations of mismanagement or failure to exercise proper judgment in making decisions that impact the business and ultimately the stakeholders. The policy can pay damages if the director is found to be negligent and liable. In so doing, the proceeds of the policy will rectify the damages rather than the director's personal assets being affected. The Companies Act allows the company to pay for this insurance on behalf of the directors. Directors and officers insurance may not indemnify directors for criminal or reckless behavior. However, the policy can provide defense costs up until judgment is made.
Great, so I hope you enjoyed that short video and that you were able to hear it. In our first session, we had a few technical problems, and so I really hope that that was useful. I trust that you have some questions that potentially we could answer. Justin would just come in and take some of the questions that you may have put onto the chat box, and we'll be happy to answer any of those as best we can.
One of the first questions I've got is some brokers are asking us about our COVID-19 endorsements. What is our intention there, and what cover still are we providing for DNO with this endorsement?
Okay, so yes, we've had to respond to the change in risk landscape that we find ourselves in with the COVID-19 pandemic, and we have considered where we need to amend our policies and or endorse them to cater for this risk. In respect of directors and officers liability, we want to still always have the directors protected. I mean, that's the intention of the policy, and to have them defended in the event of allegations brought against directors for wrongfulness. And so we do have an endorsement that will be applied to new business and renewals going forward. But essentially what it says is that it provides a sublimit equivalent to what we would normally give as sublimits in our policies for defense costs in defense of any claims alleging wrongfulness as it relates to COVID-19, but we also extend that to a sublimit for actual damages claims. So we have seen some endorsements and exclusions coming through from the market, which are absolute, but in terms of our directors and officers cover, we are not giving an absolute exclusion, but rather, this endorsement which allows for a sublimited cover, including costs to defend the director, as well as some limited damages cover going forward. Great
stuff. Chana, we've got a good question from Gustav on the chat, so thank you, Gustav. And he said, could you just explain the cover afforded under Section B, i.e. indemnity of the company? Could you just go into a little bit more detail of that?
Yeah, sure. In terms of a company's MOI, Memorandum of Incorporation, they can agree to indemnify a director in the event of a claim brought against them. In the South African context and under the Companies Act, our legislation allows for companies to indemnify directors. That's not the case in every jurisdiction. So if you take, for example, Namibia and other jurisdictions, you aren't allowed to indemnify a director for a claim brought against them in their personal capacities. So in the South African context, the Section B of the policy provides cover for where the company, in terms of its MOI, has indemnified the director for a claim brought against them and wants to recover that indemnification under the policy. I think what's important to understand, though, is that the trigger of that Section B is still a claim against a director in their personal capacity. The company as an entity doesn't benefit from the policy. If the claim is against the company, it must be against an individual director.
And Jono, there's a really good example in the news right now, and I guess it leads into my next question, but the example is Elon Musk. So I'm not sure if any of you have been watching the news, but Elon Musk, the founder and CEO of Tesla, was not happy with the increase in rates of Dno for Tesla. So he sent out a note confirming to his directors that he would stand good in his personal financial capacity for any claims against the directors. Now, it would be just good if you have any thoughts on that. Is that possible? Is that a good idea, or are there challenges with that approach?
Yeah, I mean, look, it is possible. Obviously, it doesn't translate to a transfer of risk to an insurance policy, which is essentially what insurance is there for. It's a transfer of a risk. So whether you're looking at directors and officers liability, professional liability, or assets insurance, it's saying, well, what can our balance sheet take? What is our risk appetite, and what can we fit ourselves? So there would be a deductible that's perhaps applicable to any line of insurance, and where do we want to transfer that risk to insurance? In the case of Elon Musk, what he said is, the cost to transfer that risk to insurance was proportionate to the risk that they perceive, and he would rather, pick up that risk himself. So in effect, there's no insurance policy there. It would be, the good word of Elon Musk to his directors that he would indemnify them in the event of a claim.
So probably a more appropriate response would have been just the company taking a bigger deductible, but still having the mechanics of a contract and a policy in place.
Yes, I think so. You have some certainty around, as you say, a contractual obligation under insurance policy to make good on a claim. A claim against an individual director in the context of that business could potentially be an instance where, there's some fallout in favor between directors, and, they don't want to actually indemnify that individual. So it might be something that, ultimately doesn't get picked up by, somebody's word to cover in terms of an indemnification. So it would very much come down to how that is contractually been agreed. If I was a director in that business, I would want to make sure that that was very tight, if I wasn't able to rely on an insurance policy.
Great. We've got a great question from Warren Conradi, so thanks, Warren. And John, he really just wants your outlook on Dno rates. And obviously we're in a bit of a perfect storm now with, due to COVID, there is a lot of insolvency, a lot of challenging times. So I think there's increased risk for directors. I think you could maybe comment globally on what you're seeing the global markets in Dno doing around the world. And he's talking particularly about the construction sector, but I think this general trends would be good if you could talk about your outlook for Dno rates given COVID and global trends.
Hey Warren, hi, thanks for the question. I mean, we're definitely seeing an increase in rates for directors and officers, and that's probably come over the last 12 months or so. We are in a hard market, and at least a hardening market for a lot of the liability lines, but directors and officers, I think, is one of the lines that has surprised a lot of the market and brokers and clients alike with the significance of the rate increases. So if we look into the London market and international markets, those rate increases are going up sometimes 40–60% on particular classes. And we are seeing a rate increase in the South African context, not to that degree, but I must say that it is quite risk specific. So, we're seeing anything from sort of 15 to 25, 30% rate increases depending on the risk. I think suffice to say there has definitely been an increase in notifications and activity around directors and officers as a class of insurance, and a lot more action in terms of the actual payments that are being made under directors and officers policy. So yes, we're starting to see a hardening in the rates, and I think that will continue for at least another 12 to 18 months as we see how this COVID-19 pandemic starts to pan out.
Great stuff. Thank you, Jono. We have another good question from Jimmy Black, two questions in fact, and I think just illustrates the example. This is a great time. You're online and to ask those questions that you've been wanting to know. So Jimmy asks two questions, Jono. The first is who qualifies as an officer? And then the second is, how do you manage conflict should a company sue a director for breach of fiduciary duties, and you represent both parties, I guess, kind of. How do you manage that conflict?
Okay, so let's maybe deal with the last question on dealing with the conflict. Yeah, so and we've actually had practical examples of this in the past, where a client is buying a directors and officers policy as a business, and wants to benefit from the policy in the event of an action against any of their directors. But what's important to understand with the Dno policy is that the actual insured is the director or the officer, not the company. So in this particular instance, we had the insured business suing or holding responsible one of their directors and officers. The director or the officer accessed the policy and had protection under the policy for their defense. But the client or the company itself was not able to access the policy and did not have any legal defense costs covered by the policy. And it was quite a surprise to them that they weren't able to access the policy, although as a business they were the one purchasing the cover. So the way that a Dno policy responds is that it's protecting the directors or the officers who are named under that, or not named, but who form part of that company, and they are the ones who access the insurance and not the company. I'm not sure if that kind of answers the question. But sorry, Justin, I forgot the first portion of that question. And
the first question is, who qualifies as an officer of the company?
Yeah, so you qualify. So those are quite well defined in any directors and officers wording, but essentially it is an appointed director or officer, or any senior manager within the business who's making decisions on behalf of the company. And that may extend to a number of kind of senior appointments within the business.
Great stuff. We've had a few questions about the video, so just to let all of you know, we will send an email link to the video to all of you after the session, sometime during this week, and that video is available on iTOO's YouTube channel. So if you look for it, it will be there, but we will also send you the link, because I do think that the video is a useful tool that you could perhaps even share with some of your clients if you're starting to explain Dno. So we've got a couple of other questions. We've got one from Abby, and in terms of the limit of indemnity, does the limit apply per director and officer, or is it per claim? Do you want to talk about how the limit applies, claim or aggregate, or per director or officer?
So the limits of indemnity are aggregated across all insuring clauses, including the defense costs. So it's a limit that's purchased as an annual limit of indemnity, and all the directors and any claims within a period of insurance would be subject to that total limit of indemnity in an aggregate. It could be that your policy is placed on a per claim basis or on an aggregate basis with a reinstatement. So that would obviously depend on the nature of the limit. But the limit will apply across all insuring sections and would be applicable to all directors and officers accessing that policy within a period of insurance.
Great stuff. And then, John, another question here. Could you explain the different need for EPL, or employment practices liability, and Dno? So I guess really the question is about, if you have Dno, why would you need EPL? Because I guess that's where the directors are sued for the employment practices, which you spoke a bit about earlier in your presentation.
Yeah, so Dno policies will extend to a sublimit in terms of a section for employment practices liability, and that's where a director or officer is held responsible for an action which has resulted in some kind of breach of employment practices regulation. The difference between that and an EPL policy, employment practices liability policy, is that the EPL policy covers the entity, and it includes employees and it includes directors. So the entity itself has cover under the EPL policy, whereas on a Dno policy, it's only the individual directors who have an allegation brought against them personally who could respond for an EPL claim.
Great stuff. John, a last question, which is actually from me. So really, one of the things that I find, and I think one of the reasons for this session being so popular, is because Dno is quite a technical area, and it tends to frighten a lot of brokers, but yet it's an important cover to discuss with the directors and owners and shareholders of a business. So if you could sum up in one line or one sentence, what should a broker be saying to the clients about why do they need to buy a Dno cover? Could you sum it up in one sentence? If brokers had to remember one sentence out of today, what's the one thing they should say to their clients?
Personal liability. I think pretty much sums it up. It's important to understand that the significant impact that a decision can have on a business and or a stakeholder could ultimately be a liability claim against an individual director personally. And I think that is the most important thing to understand, is that I don't think in this day and age you can afford to be without this kind of cover, given the challenges that we have to face as directors and officers leading organizations into the future.
So there you have it, brokers. You have one thing to say to your directors that you're meeting is personal liability. And I really genuinely do believe that any director and any officer of any company, even a small or medium business, should have some basic cover. What I think is really good about this cover is it's actually pretty cheap for SMEs and for smaller limits. It's relatively cheap cover. So personal liability, and I hope you can go out and sell some Dno cover to your clients, because it is cover that they need. And of course, particularly on now, one of the things that we've learned is iTOO, we're available on a video call like this. So at any stage, if you'd like us to engage with a group of your clients or one of your clients, we obviously don't give advice. That's your job, but we really are happy to work with you and to help explain some of our specialty lines of business.
How's it, guys?
Who's that there?
It's AB.
AB, how's it going, man? Thank you for the question.
Yeah, no problem. I just want to find out from you guys, would a Steinhoff type matter fall within a Dno policy? Would Marcus used to be defended by the Dno policy of Steinhoff?
So that's a great question, AB, and I'm sure John will give some views. So to those other brokers that are listening, you may want to listen to this question, because I think it will be some interesting insights. So John, do you want to answer that?
So yes, I think a directors and officers liability policy would respond to any allegation of wrongfulness on the behalf of a director in their fiduciary duties to a company. So there was clearly some wrongfulness in the Steinhoff matter, and where an action is brought against any of the directors in their personal capacity for their involvement in any of those decisions that were taken, then yes, the Dno policy can respond to that claim. What will practically happen is that it would run its course through the judiciary. The policy would respond to pay costs in defense of that individual right up until a final adjudication. So it could even be that a high court finds that the wrongfulness was in fact deliberate and or fraudulent, and that could be taken on appeal and appeal and appeal until in a final adjudication. If ultimately it is found that any actions were in fact fraudulent, deliberate, the policy would not respond to any of the ultimate damages awards, because we wouldn't be covering any kind of fraudulent or illegal actions, but the policy would respond in terms of defense costs for that individual right up until the final adjudication.
Sorry, just to piggyback on that, okay, presupposing that he's found to be fraudulent, given that the policy will not respond, does he now need to pay back all of the defense costs that the policy would have paid for him to date?
Yes. Yes, it does. So the policy does state that where defense costs are advanced and it is ultimately found that the individual is fraudulent or there was some misconduct, it is repayable to the insurer. Practically speaking, it very much depends on the situation as to whether or not you can get that money back. But yes, it is a requirement under the policy that defense cost is paid back.
Thank you, Abe. Really great question, and thanks for it. So if there are any other questions, feel free to ask. Great learning for me personally on that question. And if anyone wants to say how's it or goodbye or put on your video or shout out, that would be fantastic to hear from you guys.
Yeah. Thanks, James. I'm off. Thanks, Tab, for inviting me.
Cheers, guys.
Good. Thanks, everybody.
Cheers, Abby.